Okay. Well, I got 2:45. Sure. Yeah. Yeah. Okay, so I'll make a statement and then happily take your questions. My name is Michael Bryant, Bryant. I'm the Executive Director and General Counsel for the Canadian Civil Liberties Association. I am joined by our lawyer on this file from Fogler Rubinoff at Young Park, PARK. We today launched our litigation, brought our application to the Superior Court of Justice to nullify the Quayside project headed by Google Sidewalk Labs. The applicants are the Canadian Civil Liberties Association, one of, if not the most active human rights organization in the courts in Canada's history, and Lester Brown, a concerned citizen who resides in the neighborhood adjacent to Quayside. The respondents in the application are Waterfront Toronto, which is created by legislation by Queen's Park here, and our three levels of government: federal, provincial, and municipal. There are no private parties named in the application. We're applying for a reset of the project because Waterfront Toronto and our federal, provincial, and municipal governments sold out our constitutional rights to freedom from surveillance and sold it to the global surveillance mammoth of behavioral data collection, Google. Who we are, our very identities, what we do, our behaviors, our preferences, weird or common, and the inferences that may be drawn from these behaviors, all this stuff is surveyed when we go about our daily business online. Google and their competitors take that stuff about us and they sell it to businesses who make bets on what we will buy. Google's sibling, Sidewalk Labs, takes surveillance to a whole new level. Out of your search engine and onto your sidewalks, streets, and across the waterfront, even into the housing and businesses located within the project, and then back outside to every square inch of all those acres of the Quayside lands, development, and beyond. So the laboratory of Sidewalk Labs, Google Sidewalk Labs, the laboratory of Sidewalk Labs, you see, is your community. Google calls it a global test bed. These Google Lab scientists profit from your behavioral data. Canada, Toronto, you are the lab rats in Google's Sidewalk Lab. Our job at the Canadian Civil Liberties Association is to say to all three levels of government, the Canadians should not be Google's lab rat. This lab needs to be shut down and reset. And that's why we are seeking to nullify the contracts that set up this laboratory called Sidewalk Toronto. The problem is less that Google and its siblings want the lab in the first place. The problem is that Waterfront Toronto and our governments let this happen. And instead of Waterfront Toronto being a land development headed by property management experts, Waterfront Toronto played the role of privacy czar and established Canada's first ever public petri dish of data. Who inked this deal? Our current Prime Minister, seduced by the honeypot of Google's sparkling brand and promises of political and economic glory, joined with provincial and municipal governments to ensure that Waterfront Toronto signed a deal they never knew. So the Canadian Civil Liberties Association, in the name of our collective and individual privacy rights, our freedom from surveillance of our behavioral data, and in the name of our dignity today challenge that deal, challenge the underlying agreements, and seek a reset of the waterfront development. We are doing so not just for the people of Toronto who are affected or the tourists who may be passing through Quayside Labs. We are doing this for all of Canada. We're saying that in the growth of surveillance capitalism across our country, Canadian Civil Liberties Association is drawing a line and saying that the public collection, the public surveillance of our behaviors without any lawful authority is one step too far. So we are doing this for the future Sidewalk Lab of Vancouver and Winnipeg and Halifax and Hamilton and Montreal, and for the entire country. The federal government and the provincial government have begun the job of putting together a privacy policy for infrastructure, but they haven't done the job. And what they've done, of course, is allowed Waterfront Toronto to strike a deal where they outsourced our privacy rights and the supervision of our privacy rights and our surveillance to the very company that's doing the surveillance. And so on the basis of administrative law and constitutional law, we're making this challenge. I'm here with Young Park, who's going to help me answer questions from Fogler-Rubinoff. We're very grateful to that firm for having the guts and grit to take on this fight. So I'm happy to take your questions.
What's the next stage? So it's filed, Michael. Are there any future dates? How does this work its way through the system?
Do you want to talk through it?
Yeah, sure.
So the next stage is for CCLA and Mr. Brown to file a record. And so that'll be done within 30 days. And we want to do that and secure dates for the hearing of the application on the merits before the MIDP is finalized and before the MIDP is put before Waterfront Toronto's board for approval. So there are no dates to answer your question yet, but the process is underway to move this forward to secure dates.
And we've got a cap. We need to get our record in within 30 days.
Those initials again were?
Young Park.
No, sorry, on the MIDP.
MIDP.
Sorry?
MIDP. It's the Master Innovation Development Plan.
Okay.
And so that's the next stage of this project. That's what Sidewalk Labs is working towards right now, is to develop the Master Innovation Development Plan, to put that to the board for approval.
So, Michael, in a statement from Mayor John Tory, he said it's been clear that any final proposal from Sidewalk will be given public scrutiny, public consultation, etc., and obviously a final consideration by Waterfront and Council, and that it'll apply to some of the issues that are being raised by yourselves. Do you, in raising this, does this signal that you just simply don't have confidence, at least because it's obviously a challenge on all three levels of government, but based on what the mayor is saying, is it fair to say that there just isn't confidence at the municipal level that they're doing the proper scrutiny? I mean, or do you feel that ship's already sailed?
Well, the ship sailed in this sense. The best analogy is tragically what happened with this Boeing 737s. So FAA tells Boeing, you're in charge of safety certification. That was part of the procurement. And even though they were in a conflict, they did that. Well, it didn't work out with Boeing 737. Similarly, Waterfront Toronto, without having the jurisdiction to do so, never getting the jurisdiction from the city, which has to explicitly give to Waterfront Toronto this power. They said, okay, Google, you're in charge of the public interest and privacy rights. You need to subordinate your duties to shareholder value to the public interest. And you, the ones who are vacuuming up all this data, you need to put the public interest first and determine what is in the best interest of the public and write the privacy rules. Regardless of whatever confidence you might have in that organization, that job should be done by our democratically elected officials, not by the very company that is going to be profiting from this. So the response to the mayor is you put the cart before the horse. By allowing Google to design the tests and the privacy rules, it also means that Google gets to decide what they disclose and don't disclose to the city. And they get to obviously create a privacy protections that they know that they can fulfill, and the City of Toronto needs to decide beforehand what should be given up to the public. And there's an argument, and a pretty good one, that the city and the province and the federal government have got to grapple with and haven't yet. And that is, can you ever give meaningful consent to giving up your data while walking down a street or walking down a sidewalk or walking onto a bus stop or signing up to a social housing agreement? And there's an argument that you cannot consent to that, and that you should not consent to that. And, in other jurisdictions, they figured it out first. So in Smart City Barcelona, they determined the rules in advance. They decided who would own the data in advance. They decided what they could collect and what they couldn't collect. And then they went out and found the Google or the Google equivalent, the technology provider, to fit that bill. Instead, they've got it backwards, and Google is necessarily in a conflict.
In covering, I know, past parts of this whole struggle, I mean, we've certainly heard, feedback. I mean, you talk about the public. We've heard feedback on that, on the opposition to this, and I'm sure you've heard it too. I'm sure you've gotten it all the time. Who elected you to potentially disrupt this potentially economic boon that obviously the other side has been pushing? I mean, how do you answer that question? How do you answer, who are you to try to derail what could be a big economic opportunity?
Who are we? Oh, yeah.
How do you answer
Sure. I mean, since the 1960s, CCLA has played this role of often standing up to, in the name of something that is quite unpopular, in order to fight for people's rights and freedoms. So in this case, we're saying that the rights and freedoms of Canadians trumps whatever economic opportunity arises from this, for the reason that they are fundamental to our being and to our dignity and to our privacy and to what it means to be a Canadian. And the problem here is twofold. It's the rights affected, but secondly, the system that was set up to do this was inconsistent with the law. Waterfront Toronto never had the jurisdiction to do this. They were never given the jurisdiction to do it. And whether or not the various governments had the power to give it to them is one thing. But they never did. So Waterfront Toronto is acting like a privacy czar, even though it doesn't have any powers to do so. But then this is the double whammy of jurisdictional error. They then farm it out to Google and outsources it to Google. And that's a major part of the challenge, is that Google doesn't have the jurisdiction to determine the privacy rights of Canadians.
Is a decision to launch this kind of challenge purely within the organization and speaking with other lawyers, or is there some sort of other, community outreach or business outreach to decide that this is what you feel? Because obviously you are, like you said, this is you are going to have an unpopular resistance to this. So the decision to do this, is it purely within the organization, or is there some other kind of non-legal outreach, if you will, to determine that this is the proper challenge to take? I'm not sure if answer that question.
Well, I mean, that is, it's a good question. It is squarely within the CCLA and our membership and our board that we decide to do this. However, there are other organizations out there that could are pursuing efforts to block this project as well. So it's up to other organizations to weigh in if they wish to weigh in. The named parties are the named parties, and we want to proceed as expeditiously as possible because they're going to argue that we're both premature in our argument, and we took too long to bring it. And we're ready for both. People who have further questions about this, please turn to ccla.org for more information about this case. If you have any more questions, I'm happy to answer them.
Well, maybe just one more, at least for me, Michael,
Sure.
Is it fair, I'm just trying, because I'm, in an overall sense here, is it fair to say that is there any world where you could be convinced where this is above board, where this project would work, or as it is at least previously designed, it's just simply, it's just unacceptable?
No, if you have the law, if you create the policies and it's done in a lawful fashion and it's done in a way that's consistent with privacy rights, then 100%. This isn't about opposition to development of these lands, and this isn't about opposition to Google or Sidewalk Labs or Alphabet. This is about the grave error that our three levels of government made in conjunction with Waterfront Toronto in not protecting our rights, and of course setting the precedent for future such projects across this country where the cart comes before the horse. And we're saying the rights and freedoms come first, and then the project comes second. The project needs to comply with the rights as opposed to the democratically accountable people having to go through whatever the proposal is. We've got it backwards here, and as it turns out, backwards without any jurisdiction to do so.
Have you got any either support or buy-in or from the various privacy commissioners, the federal or the provincial folks?
I think the privacy commissioners have made some comments about it, but the challenge right now is about the applicability of the privacy commissions and commissioners. And right now, there is no application of arguably of the privacy legislation, and that's obviously absurd. Sorry, I got something in my eye here. Okay, thanks everybody. If you're looking for a link of the application, it's in the CCLA website.